Your Honour, that brings us to our defendant's next submission, that it cannot be said that the provision of a security guard or having a security system in place to deal with the criminal conduct that arose would have prevented the plaintiff's harm. This conclusion has been drawn for three reasons. The first of which is regarding the plaintiff's claim that my client breached their duty of care to their patrons by not supplying a security guard on the night of the incident. Your Honour, may I draw your attention to a number of facts. The incident occurred on a Sunday evening, after trading hours, which are typically slower than most and generally do not attract as many intoxicated persons as, for example, a Friday or a Saturday night. Taking into account my client's history in trading in the retail community that he does, and the extended knowledge that he has of socio-patterns amongst patrons, it can be assumed that it was not reasonably foreseeable that an incident of the nature that occurred would happen on a Sunday evening. It is a prerequisite of a breach of duty of care that prior knowledge and reasonable foreseeability occur before the incident, to which, in this case, they did not. I make reference to this in support of the recent 2014 Queensland Supreme Court case of Packer v Tall Ship Sailing Cruises Australia. In applying the but-for test of causation, the question can be posed: would the plaintiff have suffered injury but for the absence of the security guards? In referring to the 2009 High Court case of Adil's Palace Proprietary Limited versus Mubarak, it was established that the absence of security guards was not a necessary contributor to the incidence of harm. Your Honour, as my defendant is not actually a licensed venue, I will also point out that they do not have to abide by regulations set by liquor licensing legislation that calls for, in some circumstances, added security as a preventative safety measure. However, my client does in fact hire the services of security on Friday and Saturday evenings each week, going above and beyond the statutory call of duty for a business of this nature. The next point I will raise regarding security at the defendant's venue, Your Honour, is that the incident did in fact occur after the venue had closed business for the day and actually occurred off my defendant's premises in a common area in close proximity to the lighthouse. According to the 2000 High Court case of Modbury Triangle Shopping Centre Proprietary Limited versus Ansell and another, and applied to the present case, as an occupier, my defendant owed the plaintiff a duty of care, but the duty did not extend to taking reasonable steps to prevent criminal conduct by third parties which would cause physical injury to the plaintiff in circumstances where my client was unable to control the conduct of the assailants. Also, it should be noted that while the incident did occur off the defendant's premises in a common area to which the defendant holds a shared liability with other shop owners, the same rules in Modbury Triangle Shopping Centre apply. There is a duty of care, but more so towards the amenity of the area rather than the protection from tortious third parties. The final point I will raise with regards to the issue of security furthers to my last point, that the defendant is not liable for the criminal conduct of a third party against its patrons without prior knowledge or a special relationship. This statement is supported by findings in the 2007 New South Wales Court of Appeal case of Wagstaff v Haslam. Your Honour, as I draw our second submission to close, I would like to draw your attention to our third submission, addressing the plaintiff's claims that he suffered a psychological injury as a result of my client's alleged breach of duty of care. Put plainly and simply, Your Honour, the defendant is not liable for the plaintiff's psychological injury, as it was not a reasonably foreseeable result of the alleged incident. The psychological harm suffered by the plaintiff was not a consequence of a breach by the defendant, as the harm is too remote to be reasonably foreseeable in the context of the particular circumstances. We support this notion by referring to the 2006 South Australian Supreme Court case of Halleck versus South Australia, which showed that there was no causal relationship between the actions of the defendant and the mental illness of the plaintiff. The result in this case resonates with ours, Your Honour. This case also supports our claim that considering the psychological reaction that the plaintiff has experienced to this incident, we can only presume from the information given that the plaintiff is not of normal fortitude. In conclusion, Your Honour, we refute the plaintiff's claims on the following basis. The defendant did not owe a duty of care to prevent injury from a criminal third party. The defendant took all reasonable care to avoid any foreseeable risk of injury. The defendant's lack of provision of security did not constitute as a breach of duty of care, and the psychological harm suffered by the plaintiff was an unforeseeable condition of the incident to which my client is not liable. On the basis of the above submissions, counsel for the defendant respectfully requests an order of the court in favour of the defendant, the Lighthouse, against the applicant, Mr. Gillies. Mr. Gillies should pay the costs of the trial. Thank you.